guy with a bow tie in Chattanooga, Tennessee, David Tulis.
Yes, the provincialist with the bow tie, the slow man of Chattanooga who asks the dumb questions. The slow man who is a provincial and really, though he is a reforming cosmopolite, he is indeed a provincial, almost like a farmhand. He argues that near is better than far, small than big, and simple than complex, as he espouses the very weak theory, a very weak one, by the way, theory of lococentrism, even Noogacentrism here in Hamilton County. And down in the footnotes where he uses sans serif type to argue back against the good people, he insists that personal is better than corporate and physical is better than abstract. And I say sans serif because the words used by people who write statute in Tennessee and even in the U.S. Code, they use serifs, and serifs are those little blocks that are at the end of letters, right? Like on the bottom of the letter A, you've got one serif at the bottom of the left leg and another at the bottom of the right leg, and then one at the top. The serif is actually a little knife. And what happens when legislatures write statute is that they have on all their words little knives that cut you, right? And that's because these words have force. They are powerful words, and they cut and they make their own way by force and by coercion and compulsion. Now, there's a man in Seattle who has been trying to cut the serifs off of state law and federal law much of his life. His name is Dave Merland. He runs wevgov.com. He's a paralegal and an activist and a researcher in very arcane areas. Therefore, I think he has something to say on the biggest case, the biggest liberty case in Tennessee in the past 80 years, and that is the Arthur J. Hirsch case, the state of Tennessee versus Arthur J. Hirsch, a criminal case, 4 convictions against a man convicted of exercising 2 constitutionally guaranteed, God-given, inherent, and as he says, unalienable rights, that being of the right of travel by car privately on the public right of way, and then number 2, the right to carry and bear arms, and that is guaranteed in the Second Amendment of the U.S. Constitution, and also in the state Bill of Rights. Arthur Hirsch, the fiddle man of Lawrenceburg, 65 years old, bachelor, private businessman, and a devout man. He's called the fiddle man because he plays the fiddle for the lost souls consigned to nursing homes in that rural farm community, and also in the jail where he has been himself. He has been himself as an arrestee of the good people, the Tennessee Highway Patrol, convicted on 4 counts, 3 travel counts, and 1 gun count under the Tennessee intent to go armed statute, which is a racist law brought about to disarm and defang people who at the time were called Negroes, right? They were an anti-Negro law passed by the General Assembly, the white establishment in our state after the war that freed black men, the Great War. Dave Merland, what do you make of the Arthur J. Hirsch case? What maybe in a nutshell, describe to my listener what that case is about.
Well, the case is about several things, and in law, it serves greatly to compartmentalize, and you take one issue at a time. And the case is about several things, and there's a doctrine at play, there's statutory interpretation, there's constitutional rights. So it really can't be viewed through a keyhole, so to speak. So I think it would serve your audience to pick a couple of topics and paint the landscape of the case versus the reality of constitutional rights in a couple of ways that really stand out to me when I read the decision. There's a couple things that the defendant did incorrectly to make his arguments. I can tell by the way the judge responded. The judge's response is broad, and so I feel where the defendant should have been very specific, he failed to do so. more a matter of looking at a couple of particular questions about this case, and then attacking it the way I do. I seriously doubt you are going to believe what I found in the charging statute itself.
Is that the gun statute in Tennessee?
So, there are a couple things about this, great arguments. Okay, should have done something. There is something so big, I can't believe it. I have to qualify it by saying, I want to know what you think of this phrase in that particular statute. I don't think you're going to believe it either.
Go ahead.
So, yes, I do, so I can operate my computer.
All right, sorry, I was just telling Dave Merlin to maybe not use his speaker. There's a little bit of a distortion coming through. Okay, Dave, go ahead.
Here I am. That's been remedied.
Thank you.
And the decision here, when Sergeant Reed saw that the vehicle also lacked a registration plate on the front bumper, he followed the vehicle.
Yeah.
Okay, we're talking about probable cause. The evidence adduced at the defendant's December 2015 jury trial established that on the evening of December 10, 2013, Tennessee Highway Patrol Sergeant Jeff Reed first observed the defendant driving a vehicle. This is a quote from the police report, I presume. A vehicle that had a strange registration plate on the rear of the vehicle. When he saw that it also he followed. Now, if you proved the motor vehicle code did not apply to you, all evidence must be suppressed. U.S. versus Patzer, 2003. This was a case where Patzer drove from Washington to Idaho, interstate. He drove from Washington to Idaho, smoking pot. And an Idaho patrolman pulled him over under the drunk driving statute, which says, well, first, other statutes in Idaho say this occasion, that occasion, this incident, narcotics, comma, marijuana, comma, blah, 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 several statutes. And the drunk driving statute did not mention marijuana. It said, shall not, this and that, and the other thing, narcotics, comma, and it didn't mention marijuana. And the attorney argued in district court that that's indicative of legislative intent, that marijuana be a substance, the abuse of which shall not trigger the offense of driving under the influence. And the trial court said, oh, no, he's going to prison because they found illegal weapons and drugs in his car. So they charged him federally. And the Ninth Circuit got the case, and they said, no, if the legislature intended marijuana to be in the statute, they would put it in the statute. And so probable cause was lacking, and so all the evidence must be suppressed. And so they overturned his conviction because the evidence had to be suppressed. Here, if there's no statutory foundation for the traffic stop, everything thereafter is the fruit of the poisonous tree. So it has to be suppressed. And here we have probable cause in the motor vehicle code. That's where I start. What law is the foundation for the officer's actions? And then as you go through this, he made really very little challenge to how the officer performed his duties. It's all about unalienable right to travel freely and arm himself for protection, and that the state of Tennessee could not interfere with those rights. There's the constitutional challenge. So I'm on page 3 of the decision, and it's only an 8-page decision. 6.5 of those are actual writing, so it's a pretty easily digested decision. The defendant insisted that he possessed the weapon solely for protection and that he, quote, was intending to go armed against somebody, end quote. He acknowledged, however, that he was prepared to fire the weapon should the need arise. He said that the financial responsibility law was unconstitutional because it forced him to enter into an insurance contract against his will. That is profoundly insightful. right there, misstated, but it's the first time I've seen anybody argue it besides me. You're saying that I can't get a state-granted privilege unless I waive my right against forced contract. My rights are my rights. I can't be required to exercise my rights. Offer me a state-granted privilege that's only available if I waive constitutional rights? Up the servant? I'm never going to take that from a servant. So this is a great argument. I've wanted to see waged for a long time, that you can't force me to form a contract with a private entity like an insurance group or company. You can't force me to enjoy my property, meaning spend my money out in private commerce. You can't require me to associate with a private entity. These violate my rights to against forced association, forced contract, and forced enjoyment of property. I can't be compelled to exercise my rights. And so this is a fantastic claim. However, I could tell by the decision he didn't argue it robustly, which I would have done. For your audience, anybody you want to write this down, I'm going to give you a web address, and I believe it's on the web. I might have erased it. I can put it back quickly enough. wevgov.com, and I'll give you the rest of that in a minute when I find that document. Now, so he's making a couple of constitutional claims, but he never gets to the statute. And really, that's where I start. You might find protections. You never know. So the case wasn't argued efficiently, but he hit a home run on a couple of issues. The judge, on a very important issue, the constitutionality of the statute, the judge doesn't say how the statute was challenged constitutionally. Well, First Amendment. Does this law?
Are we talking about the commercial? Are we talking about the transportation statute?
Are you saying it infringes on your right to religion? Are you saying it infringes on your right to associate? You go down the list of constitutional challenges you could make to a statute, and there's no particulars mentioned in this decision about what particular challenges he was making. So I feel that was a deficiency in his pleadings, that he wasn't specific enough, because if you plead void for vagueness, which I suspect he did, because the judge mentions the term carries as if it was challenged as void for vagueness. I've got a ton of case law on void for vagueness and a briefing of it. It's one of my key challenges because they've made the law so complex, of course. Many laws are wide open to that challenge. And it's a matter of then, if you're going to make a constitutional challenge, think about it. There's a case now called Hirsch that people are going to have to defeat next time they want to make a challenge. And so you don't go in half-cocked. And so I over-brief things. I brief things more thoroughly than I see attorneys briefing things. But I've also had attorneys and judges tell me I write better than all the attorneys that come into that court. So take it or leave it. So now you have this decision that's bad in a couple of ways, and they're going to love to point to it.
Well, this is only Dave Merlin. This is only the middle level court. Jay Hirsch will be appealing it to the Supreme Court.
That's good. I presume that they won't be appealing when I speak, because they have not appealed yet. And so right now I'll speak as if it has not been appealed. But anyway, there's one particular move the judge makes when he says, and I mean, this is a huge shift. There's an entire discussion that has to be had about the constitutionality of a statute, and this decision acknowledges that the constitutionality of a statute is a jurisdictional issue. The court is required to find its own jurisdiction, sua sponte, on its own mission, of its own, on its own motion, of its own volition. And So it has to assess the constitutionality of a statute. And so you look at the statute, but he doesn't identify what challenge was made by the defendant. I suspect it was void for vagueness, but he doesn't get into it. So I suspect it wasn't robustly briefed by the defendant or efficiently argued.
Well, Dave, what you're doing, I understand why you say that, but this decision by the middle court of appeals in Tennessee, it effectively ignores the travel jurisdictional challenge and Jay's detailed discussion of the statute, of his commercial nature, and that it doesn't apply to him. And even though it does summarize, I think, in favorable terms in a couple of paragraphs, his argument, it then says, well, for technical reasons, we're not going to deal with that. It's been waived. These arguments have been waived by Jay Hirsch, the defendant.
And that didn't stand out to me in my precursory review of the decision.
Go ahead.
So the nature of his constitutional challenge is a mystery. And but for the purposes of this review, there's a couple big things. For the judge to say the constitutionality of a statute, which the decision acknowledges is a jurisdictional issue, and he equates it with sufficiency of the evidence. Excuse me, that's not a jurisdictional issue. What he just did is he moved it from a severe challenge to everything the court tried to do into a challenge of whether or not there was a harmless error or a harmful error committed by the trial court. Totally different format or foundation for assessment of the argument. Totally bogus.
Well, let's
right there, a huge procedure. He might have cited a case way back when that equated the two, the constitutional challenge with the sufficiency of the evidence, but I'll bet you those facts really don't apply to this. I'll just bet you they don't.
This is David Tulis.
It's going to be a total.
This is David Tulis. We're talking with Dave Merland of WeVGov.com. He's a paralegal and writer and activist in Seattle. And Dave, the question I think what we want to ask you now is just back off from your evaluation, a kind of negative evaluation of Jay Hirsch's argument as read through the opinion of the court, which I think is somehow you're taking it on trust that the court has in its negative ruling, its negative opinion, evaluates all the parts of Jay Hirsch's argument. But tell my listener why this matters. Would you say this is an important liberty case in Tennessee, or am I overstating? I think it's the biggest in 80 years since the beginning of the regulation of commerce and transportation by the state. This is the clearest challenge of all the ones that have gone before it. Why is this important? Tell my listener why this matters.
This matters from a couple of different angles, but not with enormous gravity. It is significant to a degree because it's somebody that made, for a self-taught individual, a reasonable run at the gauntlet. And I'm really happy I see this decision before he has to appeal it, because I'm going to offer again something that had been ignored in the past. I'll extend to this man consultation about how to orient yourself in statute first and how to articulate your constitutional claims, because I've briefed all this and argued this before. And I key mostly on criminal cases, and so I don't really get into the traffic tickets and the liens and levies for taxes and stuff. But criminal defense, this is right in my wheelhouse. And you want to put the court, especially if you're moving up the line, you want to put the next court on a statutory foundation. It's the hardest thing to get away from, and it's the easiest thing for them to defend if the government loses. The court can say, hey, it's the law. And so it's where you want to be. It's the most comfortable for everybody except the prosecutor. And that's a good day in court.
This is David Tulis, and we're talking with Dave Merland in Seattle. And hang on, Dave. He runs WeVGov.com, WeVGov.com, which is a site that deals with a lot of thorny, even dangerous legal issues that confront Americans, taxation And here we are discussing the question of the right to drive. There's a challenge in Tennessee courts on commercial government. The biggest, I'd say, this is the most important challenge of commercial government in 80 years on account of its claim against the people and against the right of travel, which is a property right, the right of travel to move freely from point A to point B and not be in commerce, not be subject to any external control. But of course, one is always subject to the court, which is open. The courts are open to handle accidents and grievances among people who use highways and roads and boulevards in their cars and trucks. But does the state have the authority to forbid travel by car or truck outside of commercial regulation? And the defendant, Jay Hirsch, losing in the mid-level court, the court says no. He says yes. He's fighting on. David Tulis.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.
Okay.